Hi, everyone. I'm very pleased to introduce our second panel on equality rights and the administrative agencies. We'll have paper presentations from Professors Bertrall, Ross, and Mila Sohoni, and commentary from Professors Gillian, Metzger, and Sam Bagenstos. So both of these papers feature an interesting twist on the separation of powers, with administrative agencies stepping in to serve interests that have been underprotected or entirely unprotected by the courts. You have the bios for our distinguished panelists, so I'm not going to waste time with long introductions. Let's just get to it. We'll start with Professor Ross. We'll talk for 15 to 20 minutes about his paper, and then Professor Sohoni will talk about her paper, and then Professors Metzger and Bagenstos will comment on both, and then we'll open it up to questions from the audience. Bertrall, take us away.
Thanks so much, Maggie. And thank you, Mila, for being the inspiration for this entire symposium. She rallied the troops and got us together and got us here. When we submitted the proposal, my anticipation was a failure, but somehow it became a success. So it's wonderful to be here. Loving being at Duke. Come back here every year. It's kind of my May vacation spot, so nice to be here in February as well. So I'm Bertrall Ross, and I'll be presenting my paper on administering suspect classes. And just as a preface, I enter administrative law cautiously. I'm more of a constitutional law person. I enter it cautiously, especially given who my commenters are, scholars of administrative law and folks who have worked in the administrative state at high levels. So hopefully that will be my defense from destruction. Okay, so in administering suspect classes, I offered an interpretive account of the judicial abandonment of suspect classes that justifies administrative protection of those very classes. Now, this interpretive account is drawn from the development of suspect class doctrine, starting from its beginning in the famous footnote 4 in the United States, in the 1938 case of United States v. Caroline Products, to its demise through the development of an impossible to satisfy suspect class standard in the 1980s. Now, I argue that what underlay the judicial abandonment of suspect classes was the court's institutional concern about too much intervention into democratic politics, a concern that Justice Harlan first articulated in dissent in the 1950s, and that Justice Rehnquist gave further life in the early 1970s as the court took a conservative turn. Now, I suggest that this institutionalist account of judicial abandonment of suspect classes leaves constitutional space for other institutions, such as agencies, to provide the protections to marginalized and subordinated classes that the court has denied. Now, I conclude by arguing that even though agencies lack the counter-majoritarian feature of courts, they are institutionally better positioned to be the protectors of suspect classes. Now, my account of the judicial abandonment of suspect classes is necessarily an interpretive one. The court has never clearly explained why it has put up an impossibly high barrier for groups seeking suspect class protections. But doctrinal clues lead to my suggestive answer that institutional concerns have driven the judicial decision to abandon suspect classes. Okay, so let me start with the definition. Suspect classes are classes that the court has determined to be entitled to special judicial protection from the democratic process. Now, in the courts, this special protection comes in the form of strict scrutiny of laws that discriminate against members of the class. This application of strict scrutiny has usually led to the invalidation of discriminatory laws. The famous footnote 4 in Caroline Products provides the original justification for judicial protection of suspect classes. The Supreme Court decided Caroline Products after an era of great judicial intervention into democratic politics. Through expansive interpretations of the Constitution, the court struck down several economic and social welfare laws from the 1890s through the mid-1930s. This high level of judicial intervention produced a political backlash, as the laws that the courts invalidated in the 1930s were designed to help this country recover from a Great Depression. Now, President Roosevelt threatened to pack the court, and as he sought to carry out that threat, a pivotal justice on the court shifted and joined Supreme Court majorities upholding congressional and state exercises of regulatory authority. Now, in one of those cases, Caroline Products, the court determined that going forward, a very deferential rational basis review should be the default form of review for economic and social welfare laws. But in a footnote to that opinion, footnote 4, the court tentatively suggested that a more assertive judicial role may be justified in the review of laws that discriminate against discrete and insular minorities. Now, for the next 35 years, the court failed to identify which groups should be considered discrete and insular minorities, failed to develop a standard for such identification, and failed to determine how such groups should be protected. During this period, the court, without explicitly labeling classes as discrete and insular minorities, provided a high level of protection to certain classes through the rigorous scrutiny and invalidation of laws. One such class that received such protection was the poor. In the 1950s and 1960s, cases that Professor Adler referred to in his introductory remarks, the court reviewed 3 state actions that discriminated against the poor. The first was a law in Illinois requiring that individuals appealing their criminal conviction pay a fee for their trial transcripts. A second was a judicial application of California Rule of Criminal Procedure denying an indigent person's application for the appointment of counsel on appeal. And a third was a Virginia law imposing a poll tax in order to vote in state elections. This court struck down all 3 of these state actions as violating the Equal Protection Clause because they discriminated against the poor. Now, only in the case invalidating the Virginia poll tax did the court provide a reason for the court's rigorous scrutiny of these laws. The court explained that wealth, like race, is a traditionally disfavored basis for drawing a distinction, and that therefore the same rigorous scrutiny that applies to laws that discriminate on the basis of race should apply to laws that discriminate on the basis of wealth. While the reasoning supporting the rigorous scrutiny of state actions harming the poor came late, the resistance to such special protection to the poor came earlier. Justice Harlan subjected with withering dissent both the decisions to invalidate the Illinois fee for transcripts and the California denial of appointed counsel. Justice Harlan asked, if state fees for transcripts and California's failure to provide a free lawyer to an indigent person on appeal are invalid, as impermissible discriminations on the basis of wealth, then why not the payment of tuition for higher education in a state university, a uniform charge for water from a municipal corporation, or a uniform sales tax for goods and services? Now, Harlan concluded by noting every financial exaction that the state imposes on a uniform basis is more easily satisfied by the well-to-do than by the indigent, and under the court's logic, should be closely scrutinized and subject to invalidation. Now, embedded within this dissent was an assumption that the court did not want to go that far, as it would mean a return to a prior era of great intervention into democratic politics, something that Harlan knew the court majority did not have an appetite for. In the early 1970s, the conservative wing of the court, newly emboldened by President Richard Nixon's four appointments to the Supreme Court, began to challenge the ad hoc extension of special judicial protection to new classes. At this time, judicial majorities and pluralities began to explicitly justify special protection to certain classes on the basis of the discrete and insular minority logic. And the nomenclature also started to shift from referring to classes as discrete and insular minorities to referring to classes as suspect. In 1971, the court determined that an alienage classification would be subject to strict scrutiny. As justification, the court reasoned that aliens were entitled to special judicial protection from discriminatory state actions because they were the paradigmatic discrete and insular minority. Now, what made non-citizens a paradigmatic discrete and insular minority was left unexplained. But the inability of non-citizens and therefore to vote in elections and therefore to protect themselves in democratic politics seemed to provide the impetus for such protection. Now, despite the more explicit linkage between special judicial protection and discrete and insular minority status, the suspect class determination remains standardless. And this absence of standard left the suspect class determination subject to another angst-ridden critique. Now, this one came from Justice Rehnquist in a dissent to a case reaffirming the suspect class status of non-citizens. He argued that the original purpose of the 14th Amendment was to protect against racial discrimination, and that the court should not be in the business of, what he suggested, was the arbitrary protection of other classes as discrete and insular minorities. He noted that our society, consisting of over 200 million individuals of multitudinous origins, customs, tongues, and beliefs, and cultures, is, to say the least, diverse. It would hardly take extraordinary ingenuity for a lawyer to find insular and discrete minorities at every turn in the road. Now, in the absence of precise definition of suspect classes and a justification for their protection, the decisions extending suspect class status, according to Justice Harlan, stand for the proposition that the court can choose a minority it feels deserves solicitude and therefore prohibit the state from classifying the minority differently from the majority. Now, originalist argument about the limits of equal protection to protecting racial minorities would not gain traction, as the court had already gone too far down the road of protecting non-racial minority classes. But its critique of the arbitrary selection of suspect classes would gain traction. In a case decided at that same term, a liberal plurality of justices developed a standard for determining which classes would be considered suspect. Classes that suffered a history of discrimination, shared an immutable trait that was not relevant to their ability to contribute to society, and that was politically powerless would be entitled to protection as a suspect class. Now, to reconcile the alienage cases with the new suspect class standard, the court eventually loosened the immutability requirement to a requirement that classes share a distinguishable or observable trait. Now, while subsequent suspect class determinations involving the elderly and the disabled would turn in part on the question of whether members of these classes shared a characteristic relevant to their ability to contribute to society, the political powerlessness factor emerged as a key linchpin in the suspect class determination. Now, in the case establishing the original suspect class standard, the court defined political power according to the group's descriptive representation in politics. The absence or disproportionately low number of women in federal and state executive, legislative, and judicial offices suggested to the court that this group's interests were not adequately represented in the democratic process. But as the conservative majority secured control of the court, the definition of political power shifted from whether the class was descriptively represented in politics to whether the class had been the past beneficiary of favorable state actions. Now, past state actions favorable to groups like the poor, elderly, and the disabled suggested to the court that these groups were able to attract the attention of lawmakers and protect their interests through democratic politics. Now, this new definition of political power has proven to be an impossibly high barrier for groups seeking suspect class status to meet. Virtually every group has been the beneficiary of some favorable state action in the past. But while there's a proven link between descriptive representation and group political power, there is no necessary link between favorable state actions and group political power. Favorable state actions can arise from factors such as ideology, morality, or a legislator's sense of good public policy that is quite divorced from a group's capacity to influence politics. So why does the court embrace such a faulty standard? Well, one place to look is the past expressed judicial anxiety about too much intervention into democratic politics. Both the ad hoc suspect class determinations in the 1950s and 1960s and the liberal plurality suspect class standard in the early 1970s opened the door to judicial protection of a broad number of suspect classes. Since suspect class doctrine tends to operate like a ratchet that never closes, any decision to protect a class would result in the close judicial scrutiny of laws that discriminate against a group indefinitely into the future. Expanding such protection to more and more classes would require greater and greater judicial intervention into democratic politics over time. And what the new definition of political power provided was a way out, a way for the court to resume and preserve a default role of deference to democratic state actors. Now, this court's desire to resume this role of deference was perhaps most clearly articulated in cases rejecting a disparate impact standard for liability under the Equal Protection Clause in favor of a discriminatory intent standard. These cases are related to the suspect class doctrine for reasons I elaborate more fully on in the paper. But in justifying the rejection of the disparate impact standard, the court explained that a rule that a statute designed to serve neutral ends is nevertheless invalid, absent a compelling justification, if in practice it benefits or burdens one race more than the other, would be far-reaching and would raise serious constitutional questions about, and perhaps invalidate, a whole range of tax, welfare, public service, regulatory, and licensing statutes that may be more burdensome to the poor and to the average black than to the more affluent white. Now, in the abstract, this doesn't seem all that problematic, but the court, writing against the background assumption held since Caroline Products about a concern about too much intervention into democratic politics, knew that a slippery slope characterization of the disparate impact standard would be seen as a troubling threat to the institution's legitimacy. The judicial battle over suspect classes appears to be over for now. Now, the court has not declared a class suspect in over 40 years. But if it is right that the judicial abandonment of suspect classes is the product of the court's institutional concern about intervening too much into democratic politics, then that suggests that other institutions, not similarly constrained, should be able to provide the protections that the court has not. Now, in that 40-plus year period since the court declared a class suspect, administrative agencies have played an active role in protecting some of the very classes that the court has denied protections through interpretations of civil rights statutes. The need for compromise and the limited foresight of Congress has resulted in civil rights statutes that are often vague and ambiguous. A common feature of these civil rights statutes is a prohibition on discrimination on the basis of a particular characteristic. Now, this language can be read as protecting against the use of certain classifications, such as the use of race in governmental decisions, or as protecting certain classes from discrimination, such as racial minorities from disparately harmful government actions. Prior to the judicial abandonment of suspect classes, such critical statutory interpretive questions were typically resolved through a dialogical relationship between courts and agencies. At time, as in the case of the EEOC's Equal Employment Opportunity Commission's interpretation of Title VII of the Civil Rights Act to protect racial minorities against disparately harmful employment actions, the agency would take the lead. But at other times, as in the case of the Supreme Court's interpretation of Section 5 of the Voting Rights Act to protect the representational rights of racial minorities, the court took the lead. But regardless of which institution took the lead, courts and agencies reinforce each other's interpretation of civil rights statutes as protecting suspect classes. Now, since the judicial abandonment of suspect classes, however, courts and agencies have for the most part been acting at cross purposes. Agencies have continued to interpret ambiguous civil rights statutes as protecting class from discrimination, and this has been the case with the EEOC's interpretation of Title VII to protect pregnant women, the Age Discrimination and Employment Act to protect the elderly, and the Americans with Disabilities Act to protect the disabled from discrimination. It's also been the case in the former Department of Health and Education and Welfare's interpretation of Title VI to protect language and racial minorities from discrimination in education, the Department of Housing and Urban Development's recent interpretation of the Fair Housing Act to protect racial minorities from housing discrimination, and the recent attempt by the Department of Education to protect the poor from discrimination in state school spending. Now, when the Supreme Court has reviewed these interpretations, it has ignored the ordinary doctrines of deference that might apply, and instead has engaged in its own independent interpretation of these statutes. And while the court has concurred in the agency interpretation on a few occasions, most notably a surprising decision to interpret the Fair Housing Act to protect racial minorities from disparately harmful housing discrimination, the court's usual path has been one of resistance. For the court, it seems, deference doesn't apply because the agency, through these interpretations, has entered a constitutional space that belongs to the court. But if my reading of doctrine is right, that the court has abandoned the protection of suspect classes because such protection falls outside of its institutional role, then the court's approach to these cases should be rethought. Courts continue to have an important role to play through the application of the relevant deference doctrines to ensure that the agency is acting in accord with its statutory authority. But when it is found that agencies are acting consistent with their authority through reasonable interpretations of ambiguous statutes, for example, courts should defer. And some courts should recognize a constitutional doctrinal space for an agency role in protecting suspect classes. Now, the point I seek to make is not only a doctrinal one, but also an institutional one. Not only is there the constitutional doctrinal space for an agency role in protecting suspect classes, but there are some important institutional advantages that agencies have over courts in taking on this responsibility. Rather than engaging in the protection of suspect classes episodically, agencies are able to focus attention and resources on redressing different forms of discrimination that violate the statutes they are responsible for enforcing. The combination of mission, personnel, and constant dialogue with interested groups, such as civil rights groups, contribute to its focus on protecting subordinate groups from forms of discrimination that might elude the courts. Now, I argue that agencies are also better equipped to withstand changing ideological currents and moral pressures than other institutions of government. While the ideological orientation of the political appointees that lead agencies might shift with each new administration, for the most part, the civil servants that run agencies remain in place. These are the individuals who are imbued with that sense of mission and who sustain deep relationships with members of the civil rights community. While the civil servants cannot override the leaders placed in charge of the agency, they can engage in forms of resistance to actions inconsistent with the statutory mission, and at the very least maintain the institutional memory to return the agency to its proper course when more favorable leadership and a new administration arrives. Finally, the agencies have advantages over courts in adapting the protection of suspect classes to needs and contexts. Acts of discrimination against subordinated classes evolve as society changes and takes different forms, depending on the group. For the court applying suspect class doctrine, the opportunities for adaptation to context and needs are limited. But agencies flexibly interpreting civil rights statutes are better positioned to calibrate the protection of suspect classes to the needs of classes and the context in which discrimination occurs. Administrative agencies thus have an important institutional advantage with respect to protecting suspect classes. But I don't want to paint an overly rosy picture of agencies as protectors of suspect classes. They do have their limits. They're limited in protecting agency suspect classes by the reach of the statute that they're responsible for enforcing. They are also vulnerable to capture. And they also always operate in the shadow of courts that can always override agency interpretations for flimsy reasons or no reasons at all. So if the Supreme Court, populated by justices such as Judge Gorsuch, decides to abandon deference doctrines like Chevron altogether, agencies will be even less insulated from judicial deferences. Now, despite these limits, it is important to remember that administrative agencies are, for now, the only institution that seems to have the desire and wherewithal to protect suspect classes. Of course, we might not see much of this, much in the form of protection in the next 4 years, but they will remain as sleeping giants waiting to be awakened by an administration that seeks to resume its civil rights responsibilities. Until then, the agency role in protecting suspect classes should be protected and justified, which is what I seek to do in this contribution. Thank you.
Well, thank you very much. I really want to thank the organizers, especially Ace here and also Zach, but all of the Duke Law Journal staff and the law school for being such generous hosts to us. And I'm very much indebted to all of the other paper presenters and the moderators and the commentators for being so generous with their time and coming here and so we could all have this wonderful conversation. So this paper is motivated by a simple idea to try to show how agencies can use aggressive statutory interpretation to spend money in ways that Congress may not have anticipated or authorized. So the Obama administration gave us two powerful examples of this phenomenon. To secure widespread access to affordable health insurance and affordable higher education, the Obama administration took actions that were not required by statutory text. And my paper uses these two examples as case studies for evaluating the institutional competence of the executive branch to underwrite large-scale positive economic rights on the basis of ambiguous statutory authority. So I'm going to start with some definitional preliminaries. Here's a basic way to conceptualize different types of rights as horizontal or as vertical. So horizontal rights are those that run against and between private parties, whether their source is statutory or common law. So contract, property, or the right to a minimum wage. Vertical rights, in contrast, would be those running against or with respect to the government. And within that box of vertical rights, we can further draw a distinction between negative and positive. So negative here being rights that stop the government from taking certain actions, for example, restricting speech or the exercise of religion, and positive being rights that require the government to support or to provide something in cash or in kind, for example, food or medical care or housing. Now, in international law, people sometimes group these rights in a different way, calling civil and political rights first generation, while calling rights to economic and social goods second generation. I will generally avoid that terminology, and instead I'm just going to stick to this horizontal, vertical, negative, positive locution. So with this set out, let's then ask a question about this subject. Let's approach this subject by asking an institutional choice question. In our system of government, who should create positive vertical rights? Where should positive vertical rights come from? So each of the branches has tools at its disposal to create those kinds of rights. So, of course, courts might. And keep in mind that courts in other countries, for example, in South Africa, articulate positive constitutional rights. That's just part of being a constitutional court in those systems. Some state courts in America, I understand, likewise have authority to articulate positive rights. But in the federal system, courts have not accorded substantive protection to such rights in our law, although they have given them procedural due process protection. So the institutional option we're most familiar with is Congress. So it creates such rights through statutes, a process that Professor Frank Cross has called utterly unexceptionable. Welfare, food stamps, Social Security, Medicaid, these are all examples. And the third possibility that is less often explored is administrative agencies. So generally in American law, we group together those last two as the political branches. So you will often have heard it said that, quote, the political branches and not courts should decide if there's a right to food or to health care or to a minimum wage. And so we tend to assume that the role that agencies will play in this area is one of that of carrying out legislative commands. But agencies can also play a more significant role through the use of aggressive statutory interpretation and discretionary policy making. Agencies can also play the dominant role in creating and protecting vertical economic rights. So that's what this paper is about. Agencies using executive power to recognize and recognize and fund broad-scale economic entitlements against the government. And I tackle this by presenting two case studies, one from the healthcare context and one from the student loan context. So first I'm going to start with how this works in the healthcare context. So the point of the Affordable Care Act was to extend access to affordable health insurance to millions of people. So the problem was that when Congress enacted the Affordable Care Act, it went through a very rushed, chaotic legislative process, and that resulted in a statute that was frankly a mess. And in particular, in place after place, the enacting Congress didn't provide clearly for the funding that would be necessary to make the right to affordable health insurance a reality. And the Republican-controlled Congress that has succeeded that enacting Congress has had no interest in fixing these problems, or any of the problems with the statute. And so we have seen this core fact pattern emerge time and time again. Congress has specified subsidies ambiguously. Congress has refused to appropriate money or write statutory fixes to authorize payments. The agency, which is still committed to implementing the statute, interprets the Affordable Care Act or relevant appropriations laws to authorize payments. The agency actually makes payments to insurers or to insureds. And the upshot of all of that is that plans stay affordable, or more affordable than they would have been had the agency not taken that middle step. So the mechanics of all of this, as I laid it out in the paper, they may seem complicated. The statutory interpretations here involve abstruse sounding things like risk corridors and risk adjustments and cost sharing subsidies, things you don't want to know more about than you absolutely have to. But the core of it is very simple. There are many different subsidies. There are many different aggressive agency statutory interpretations, but they all have been leading up to a single ultimate goal: affordable health insurance. So now let's look at what happened in the affordable higher education context. So here we had a statute from Congress that expanded income-based repayment on loans for loans taken out in 2014 or afterwards. Following that, we had an administrative decision by the Department of Education to expand eligibility for loans to loans taken out in 2007 onwards, right? And then after that to all loans, regardless of when they were taken out. And then the agency further made these loans forgivable after 20 years of paying 10% of the borrower's disposable income. So commentators have noted that these programs, which are called pay-as-you-earn and revised pay-as-you-earn, and you should really look those up if you're a student in this room and you haven't already. They've noted what a sea change these programs will make. This is a huge change, one has said, in how we publicly finance higher education. Jake Brooks has said instead of loans, we have a scheme of a progressively financed income tax. Student debt exists, but it is debt without the prospect of default, or at least with a drastically reduced prospect of default. As one has commented, those who earn more pay more, returning the full amount of the loan plus interest before the 20-year forgiveness threshold is met. Those who earn less, for whatever reason, pay less. Nobody will ever default simply because they cannot afford to pay. So how should we assess these executive branch actions? Now, one obvious place to start would be the Appropriations Clause. That clause states that no money shall be drawn from the Treasury, but in consequence of appropriations made by law. And the term law in that clause refers to statute, not regulation. That clause is the home of what is called the power of the purse. But there are other elements of that power as well: the Anti-Deficiency Act, the Miscellaneous Receipts Act, and various other limits on government contracting. So these statutes dictate limits on agency spending, and they attach criminal penalties to spending that crosses those limits. Against that backdrop, it might seem obvious that agencies should not expend resources outside limits that are expressly specified in the statute. And if they do, they've violated the balance of power between the branches, and they've possibly committed felonies punishable by jail time. But it is not that simple. Every time an agency takes any kind of action, formulating and enforcing regulations, issuing a guidance document, investigating a violation, it's spending money. And it cannot be the case that every single time an agency does something like that without clear statutory authority, it's violated the Appropriations Clause or the Anti-Deficiency Act. I mean, Chevron itself precludes that notion by treating agencies as authorized to act based on reasonable readings of statutory authority. Express authority is not necessary. So the real question is whether the scenario of agencies spending money on securing economic entitlements based on ambiguous spending authority, statutory authority, poses any special or distinctive concerns that justify departing from administrative law's ordinary assumption that agencies can legitimately act pursuant to ambiguous delegations. So let's now turn to that question. And to do that, we can ask that to begin with. Why do we ever rely on agencies to do anything? And it basically boils down to this: expertise, judicial review, and the existence of legislative checks. Expertise: agencies have access to specialized information. Agencies can legislate more competently than Congress would if it did. Judicial review exists as a check to prevent agencies from crossing statutory lines. Plus, we get the benefits of agency reason-giving. And then finally, legislative checks, that Congress can oversee agency action and that it always retains the ultimate control over what agencies have done. So each of these predicate assumptions, I argue, are on shaky ground. Each is on shaky ground when it comes to underwriting broad-scale economic entitlements on the basis of ambiguous statutory authority. Consider expertise. Now, agencies spend money all the time. The NIH spends money on scientific research. NASA spends money on sending things into space. Other scientists spend money on drawing complicated chalkboard drawings. But there's a difference between an agency that is deploying resources that the legislature has allocated to it on the one hand, and an agency that is deploying resources that the legislature has not allocated to it on another. So when the agency is reaching out beyond the sums assigned to it, it is making decisions about other regulatory domains. It is making decisions about trade-offs across the full plane of government action, and indeed about successive planes of government action across time. So those kinds of trade-offs, so even if the NIH can decide whether it should fund research into Zika or TB, it does not have the expertise to decide whether funds should be available for Section 8 vouchers or research into a shuttle to Mars. No single agency has the competence to determine how allocation decisions should be made at a government-wide level. Nor, should I add, does the executive branch as a whole. So that may seem surprising. After all, the president, not just Congress, has a panoptic perspective on government spending and the full palette of the administrative state at his disposal. Even more to the point, the president actually produces a national budget annually at Congress's command, whereas the congressional budget process is broken. So why shouldn't we treat the president as having co-equal competence to Congresses to spend resources across the full domain of government action? So the main reason, I argue, is that the money to pay for the spending has to come from somewhere. And the institution that foots that bill is Congress and not the president. So it's not a coincidence that the Constitution houses within a single branch both the powers to appropriate and to spend for the general welfare, and the powers to tax and to borrow against the credit of the United States. These two sets of powers have to go hand in hand. If the executive branch can create financial obligations or generate spending that Congress hasn't expressly authorized, then it can take credit for spending choices while externalizing onto Congress the bulk of the political cost of immediately or eventually funding those decisions. So my basic point is this basic point is not a formalist one about the separation of powers. It's a functional one about expertise. Decisions about outflows are necessarily decisions about inflows. And the institution with the most expertise in and the most democratic accountability for stewarding the whole financial picture of the United States, the budget's inflows as well as its outflows, is Congress. So let's turn next then to this question of judicial review. It's easy to see why that is going to be weak or absent here. When you are spending money, it's very hard to find a party with Article 3 standing. I won't belabor that, but it was only through very odd circumstances that a plaintiff could be found in King. And you might remember the colloquy at oral argument there where the justices said, well, let's just move to the merits. Anyway, when you're giving money away, it's not easy to find a plaintiff that's been injured by that. Now, let's move on to entrenchment. So we can distinguish between two kinds of entrenchment here, formal and practical. And let's take them in order. So we tend to assume that non-constitutional law, meaning law made by Congress or by agencies, that it cannot be formally entrenched. So if tomorrow Congress and President Trump decided to repeal Social Security and replace it with a loyalty program for the Trump hotels and casinos, that would be that. But there are certain circumstances in which the federal government can bind itself in a way that gets constitutional protection. And the court recognized this in the Winstar case. If you enter a contract with a government agency, say a student loan agreement, and the agreement doesn't caveat the government's obligations, then that agreement can create a vested right that will be shielded as if it were like a fee simple estate. Also, if an agency hands out money while affirmatively representing to recipients of those funds that they are entitled as a legal matter to those funds, then undoing or clawing back those payments later on may run into various legal obstacles, takings problems, or estoppel arguments. So the overall point is that here it's not so easy to just say, well, Congress retains the ultimate reins of control. Congress can put the genie back into the bottle if it doesn't like the spending. Probably more important, though, than legal or formal entrenchment is pragmatic or political entrenchment. So you're all familiar with the idea of how Social Security is the third rail of American politics. So what that idea captures is the principle of loss aversion. The tendency of loss aversion. Once you have something, anything from a pen to a coffee cup to subsidized health insurance, you don't like to see it taken away. As the wise man once said, get your government hands off my Medicaid. And I think we can see today this dynamic unfolding with the rhetoric around the Affordable Care Act. Even President Trump has said that the act has to be replaced, not just repealed. I believe the word this morning was repaired. But who is responsible for entrenching this right? It wasn't Congress. Congress was willing to sit on the sidelines and let the act collapse. It was the executive branch, which through aggressive statutory interpretation pulled out all the stops to keep federal money flowing and plans being sold and subsidies being handed over for 3 long and critical years. It is because of those decisions that we are having a conversation today about repeal and replace, not just repeal. With the student loan programs, the picture is even more stark. Despite revelations about the mounting costs of these executive branch spearheaded schemes, is there any discussion about repeal, about undoing these student loan agreements, or about clawback of forgiveness that has been promised? Unless I missed a tweet, I don't think so. There, the Department of Education's actions may have transformed the landscape of public expectations to such an extent that even given the thunderous effects of the 2016 election, undoing these programs is not worth the political capital. So these points about entrenchment mean that in this context, it's especially important that agency action be transparent, so that Congress can perceive and check these programs if it wishes before the right becomes entrenched. And that leads to a final problem observable from these case studies about transparency. I'll not say much about transparency except to say that there's less of it here than you might think there would be. The financial plumbing of these programs has been obscure. Their inflows and outflows hard to pinpoint, even to the pocket protector wearing watchdogs and wonks in the government accounting office. And some would say, come on, these programs, the Affordable Care Act and the Student Loan Forgiveness Program, these have been trumpeted for years by the Obama administration. And it's silly, or it's at least a little bit odd, to fault them on the score of not being transparent. But without transparency around the money, I think it's not fair to say that decisions are transparent or that the decision maker can be held accountable. When your husband comes home with a brand new set of golf clubs, you can see the golf clubs. The real question is, can you see the credit card receipt from when he paid for them? Only when you've got transparency around the money have you got what I'd call transparency and accountability. Or at least that's how we run things at my house. So to sum up, I hope that I've been able to convince you that serious reasons exist to doubt whether in this domain the executive branch should be afforded the leeway that it's regularly accorded in construing statutes. Let me just stress here, because I haven't before, that these agencies may have acted in a way that aligned with many voters' preferences and in a way that increased the economic security and opportunity of millions of Americans. But as these examples also make apparent, this type of agency action can undercut congressional control over matters of long-term spending and resource allocation, can be accomplished with little transparency and without the checks of judicial review, and can unilaterally cause policy entrenchment. So today, of course, we are at the cusp of a new administration, and this new administration may have a very different view of economic rights and of the kinds of spending that must occur in order to protect those rights. And so, while I also hesitate to venture any guesses about American politics in this moment, I will hazard the prediction that in the years to come, we will continue to confront the question of how much leeway should be afforded to the executive branch when it seeks to engage in broad-scale spending to secure economic rights.
So, again, I also want to start with thank yous to having me here. I'm enjoying the presentations, and I have enjoyed the papers very much. And a special thank you to Mila and Bertrall for giving us two very interesting papers to comment on, both of which take up, share similar concerns, obviously, with thinking about equality and inclusion and what its impacts would be, different institutional foci, which was quite a nice contrast, and of course different assessments, which I also appreciated. So what I thought I would do is begin with some comments on each paper individually and then hit on one general point. So Bertrall, let me start with yours. And one of the things that's really nice about both these papers that I just wanted to flag is that both of them are interjecting into academic debates on many fronts and contributing to multiple academic ongoing debates. And it's quite nice to have papers that are that sort of bringing together literature. So for Bertrall's, first of all, there's a very big or growing debate going on right now about what does the Constitution say about economic inequality. And there's been a fair bit of scholarship on that, and Bertrall's is a really nice interjection to that debate. You've heard mention of the administrative constitutionalism debate, so he's participating in that. And then he's also linking them to a debate that I don't think is as much linked to these, maybe to the first one about economic inequality, a little less so administrative constitutionalism, about how should we understand equality and the anti-subordination and anti-classification pieces. So that's a really nice combination. As he described to us, in his account, agencies have stepped in to address inequality and discrimination where the courts have pulled back. And then he makes some very interesting points about agencies' special competence here, their ability to be very contextual, their mission-drivenness. And in other writing, I've also I signal my agreement with some of these institutional points about how agencies have particular benefits in developing constitutional meaning. What I want to focus on is really sort of parsing some of the details of Bertrall's argument. And in particular, Bertrall, the question that I had, and I got a little bit more clarification from your presentation today, but was about how you think the existing structure of judicial review should change. And as you noticed, these actions by agencies are not just based on the Constitution, right? They're based on a statute, and there'd be ordinary rules of deference that would apply to administrative agency action interpreting those statutes, right? So one possibility that you allude to in the paper is an argument for strong deference where over the years the court has refused to apply it. So EOC, for example, in some contexts, right? Or other instances where the courts just have pulled back from the ordinary deference rules, right? And I heard you making that point in part, at least, right? But I also heard you emphasizing that agencies are limited by statute. So I didn't think there you were really saying something that would go beyond the scope of the statutory delegation. A second way of understanding what you're arguing for fits with some of your prior scholarship. And again, heard you talking about this more so today about what you really want is to push courts to adhere to those ordinary doctrines of deference, which Bertrall has a great piece talking about administrative constitutionalism with civil rights statutes, talking about how they don't do that, and trying to push them to do that. But I read this piece as doing something more, and this is where some of my questions arise. There's a third possibility, which is that what you're arguing for is greater deference than would be ordinarily applied, precisely because constitutional equality rights are at stake. And I think this fits with your point about the judicial pullback, right, the sensitivity judicial role. And it also fits with your comment that if that pullback turned on the substance of constitutional rights, then what agencies are doing would not be legitimate, right? So I think this is definitely something that you are pushing for. I think it's actually a more radical option than you currently acknowledge in the paper, and I think you should give yourself more credit, but sort of engage a little bit more with it. So first of all, in this idea of if courts are pulling back because of the judicial role, agencies could step in and interpret constitutional rights more broadly, that has a kind of a real appeal. It also sounded a whole lot to me like Justice Breyer's dissent in City of Bernie. And the problem with that is, of course, it's a dissent. Now, you can take on Bernie, for sure, and you can distinguish, right? Not talking here necessarily as clearly about federal regulation of state and local, although I think actually some of your examples do fall in that box. But I think you got to grapple with that. The other thing is, so if you want extra deference because it's constitutional equality rights, and to invoke the looming presence over all of us, I think you have to deal with the question of retrogression. And how do courts respond to agency retrogression? Should they still get broad deference? If not, why not? Because your same arguments about competency and expertise, I think, would apply there. There's a third point here to think about, which is to what extent is having independent judicial enforcement on constitutional rights actually important for administrative constitutionalism's legitimacy and development? Because one of the things that you see is this dialogic relationship to existing doctrine and statutes and agencies. And if you're pulling away the courts, it could well be that one of the bastions for that disappears. It makes me think of, actually, Nina Pillard has a piece where she talks about government lawmaking and how important it is to have judicial decisions that then government lawyers can push agencies to agree with, right? So there might be some concerns about pulling courts too far out. And then, of course, if you're not arguing for this, although I think you are in some ways, then more explanation of why not. Okay, so let me turn now to Mila. And again, this is a really interesting piece. I really enjoyed this. And again, lots of very interesting debates. One, again, is administrative constitutionalism, right? So both of these are really interesting from that angle. One of the really nice things about Mila's piece is that she's actually engaging with an academic debate that hasn't been anywhere near as robust as it needs to be. And so it's a very important contribution to that. And that debate is about money and funding as tools of governance. These have become increasingly central. Over the course of the 20th century, money became much more of an important metric of how we govern with the growth of cooperative federalism, many features of our regulatory state and social welfare programs. But we're seeing even more of this in the 21st century, and it's become more central. And you see that from the examples in Mila's paper, you see it from Alati's paper, you see it from a lot of different papers that are presented. And there's several causes. Some of it is politics and optics, right? So we've had some very high-profile funding measures like TARP, the stimulus, the Affordable Care Act, the Medicaid extension, a lot of debt ceiling standoffs. I mean, you think about it, and you think about a challenge in governance, and it usually has right now a very significant funding aspect to it. And as a result, it's also, the reliance on funding is also a reflection of increased polarization and divided government. And appropriation measures being increasingly a core mode of legislation and of engagement and pushback from the executive branch, right? So you could see, I think, funding as really a mechanism of governing under gridlock. Now, and as a result, that creates a lot of implications, like what are the implications of this funding machine? I'm sorry, there's one person in this room who I didn't mention on this, and I can't believe I didn't, but she's sitting right there, which is Eloise, who has written fantastic stuff on this, and it's in my notes, by the way. So, I think this is really the challenge to add to ad law our understanding of this dimension and dynamic, and so Mila is contributing to that, which I think is fantastic. So again, my questions here, Mila, are on the scope of your arguments, right? So one theme that you come back to, one of your main claims, is that the Obama administration is stretching statutory authority, right, to the max to achieve equality goals. And I wanted to push you on how central that is. So for example, would you be as troubled by agency action that advances equality goals through spending if it's more within what you consider the reasonable ambit of statutory scope? I'm not sure why you wouldn't be, because I think you still have the same concerns about entrenchment, trade-offs and expertise, lack of transparency, won't be any judicial review. All those things are there, even if it's more reasonably within the scope of the statute. And today I heard you being more sort of advancing kind of a clear statement rule, which I found in pieces in the piece. In the earlier version where you took on King, it was clear, right, that was where you were going. So one question is, just to clarify that is what you're arguing. And if you are, then I think you have to sort of justify some lines that you're drawing more carefully. So one would be, or just engage perhaps with them more, because I think there's a lot of care in your analysis. So the distinction between spending and regulation, or between what's authorized and not authorized, right? I mean, in your examples, they're complicated regulatory schemes, and certainly not everyone. Oh, okay. I was surprised I had that much time left. And not everybody would necessarily agree with your characterizations here, right? So I think you need more of a theory about how we make those determinations. I don't think it's always going to be clear when you have, for example, a federal rule that imposes on state Medicaid programs certain requirements of what services they have to provide. Are we in the regulatory box? Are we in the funding box? Does that have to be clearly authorized or not? There's just a lot of ramifications there that I think need to be addressed about how we would implement it and whether those lines can be drawn. I also query whether spending and allocation decisions are categorically different in what you're calling expertise and entrenchment. There are always trade-offs. And I think you acknowledge that. I think your point about trade-offs is that the trade-offs are over a bit bigger range, right? And I'm just not entirely sure that's always so true across, car seats versus environmental protection. I think often those kinds of trade-offs are going on. We have centralized agencies like ORIRA, whose job is to be taking those kinds of costs trade-offs into account, and that's not part of your picture right now. Another way to get at this is, I'm not even sure that that all commitments of government funds really are that cross trading costs. I think what you're really focused on are major commitments of government funds, and if you take that major commitment focus, and in some sense, I think you're talking about the major questions doctrine, right? But you're expanding it to include funding. But then I think you also have to deal with the challenges brought to major questions about what's a major question, what's not a major question, how do we really implement it, right? So I also had a couple of comments on the expertise argument, which I think I'm just going to pass on here in terms of time. But one point I do want to say is, I think that one of the things that's really interesting about appropriations, particularly and funding in this time, is it not only is a different mode of agency action, it's a different mode of congressional action. And one of the things not yet in the paper are, to what extent are appropriations and money a tool that Congress can wield more effectively in terms of oversight and what we might call accountability than traditional major substantive statutes, right? And the reason is because we see them doing it. We see tons of appropriation writers. We see lots of hearings about spending. We see there's a lot of ways in which Congress has been also responding to divided government and gridlock through money. And so I think you're only telling the agency part of it, but you also have to tell the other part. That wouldn't, I think, necessarily undermine all of your critiques, like transparency. Congress may not being very transparent about it either, right? But I think it's a complication to the story that it would benefit from having. Okay, so my final point, sort of seeing these two together, they obviously share really nice, nuanced assessments of institutional competency, and the ad law geek in me loves that. I like the fact that it's the different institutions here, as I mentioned at the outset as well. The broader thing is, of course, the constant administrative law focus and obsession with legitimacy and accountability in administrative government, right? And here they reach different assessments about that in a very interesting way. With Bertrall, I think, emphasizing much more substantive legitimacy in terms of sort of substantive commitment to protecting marginalized classes, and then agencies' better accountability to that compared to courts. But at times, Bertrall, you present political accountability as more of a threat, particularly presidential oversight. Whereas Mila, I see you putting more emphasis on political accountability, very skeptical about justifying agencies based on substance, right? You acknowledge that the result of this action may actually be a very good result, but that's not factoring into your account of accountability. In fact, you're insisting that we bracket that. And when it comes to accountability, I actually thought that you were defining it more formalistically than you said today, because it seems to me that it's accountability to funding choices of the current Congress, not to the president, not to former Congresses, and not to the constituencies who work to enact these statutes. So in some sense, I actually see that as a more formalistic and narrow understanding of political accountability. And I guess my point to both of you is I actually think there's merit to both counts of accountability. But in general, one of the challenges for administrative law is we have got to expand our understandings of what counts as accountability. We heard this with Alatis and the debate this morning, but there are many forms of political accountability. The substantive accountability also factors in, and we're often falling back, I think, on trying to find simplistic accounts of accountability that we can justify with separation of powers or some overall metric that don't reflect the reality of administrative governance, which is far more messy than that, and that don't further what has to be, I think, is a broader societal discussion about what do we mean by accountability and how do we come to terms with it in a way accepting that it's not going to be clearly linear or clearly resolvable on a particular metric. So I think both of these papers are good in showcasing some limitations on some accounts of accountability, but also part of the earlier panel in terms of grappling with how we should really understand that. So thanks very much.
Great, thanks so much. I'm just gonna record myself here. So this is really terrific. I am incredibly honored to be at the Duke Law Journal Administrative Law Symposium, which is like one of the premier events for scholarship in America every year in the Legal Academy. I mean, honestly, and as someone who's not an administrative law person, I'm especially honored. As someone who's a Carolina graduate, I'm even more especially honored to be here. But to be here with all these terrific presenters who are folks who have done such great work in so many places and have done such great work today. It's amazing. So thank you to all. And I think I'm now about to prove why I've never been invited to this before and may never be invited again. Because so first of all, these two papers are fascinating, terrific, really interesting papers. They're very rich. There's a lot of great stuff in them. I think Gillian gets it exactly right that they draw on and contribute to so many different literatures. There are a lot of different strands. I'm going to focus on the strands that I think highlight basic problems with administrative law scholarship in general, and particularly a kind of administrative law and public law scholarship that I'm shocked that we're still doing. And that is this sort of institutional competence kind of scholarship, which seems to me particularly inapt at this moment in time. And I think there's something about the transitional nature of this symposium, right, when it was conceived, when it's being executed. But I do wonder about these papers, and actually many of the papers in this symposium. Where's the politics, right? So what you hear in these papers is a story that is a very abstract story about how institutions work in some generic sense, that is denuded of political context. But the stories of the particular case studies discussed here are all stories that are deeply embedded in a kind of politics. And it's there in the papers, right? If you read the papers, if you read the stories, right, Bertrall and Mila know that the politics are there, and at various points it comes in, but there's this effort to abstract from that. And I want to suggest that is a mistake here, and it's a mistake in this kind of work. So let me talk about Bertrall. So I think Gillian frames it almost exactly the way I would frame it. There's a strong and a weak version of the claim in Bertrall's paper. The strong version of the claim is that in the second half of the paper, the ad law part of the paper, and the strong version of the claim is that because there's something special about administrative agencies with regard to their promotion of suspect class protections, there ought to be some especially strong kind of deference to them, something unusual. The weak kind of claim is, well, just as Bertrall has argued very well in other work, at the very least, agencies that are trying to protect civil rights, that are trying to protect suspect classes, ought to get no less deference than anyone else. And I'm looking at Hy Feldblum. I've long had a view about EEOC deference, about as the practical view of what happens to what the EEOC says, which is when the EEOC issues some rule or some order or some interpretation that protects employees, they get no deference, and when they issue some rule or interpretation that favors employers, they get absolute deference. Which again, but they don't get the kind of deference that we read about in the case books. And so I'm wondering, and that suggests, right, there's a political critique buried in there, that suggests to me that perhaps looking at the politics, the political situation, undermines both the strong and the weak versions of Bertrall's claim. So the strong version of Bertrall's claim, right, it's based on notions of institutional competence and legitimacy. So the competence arguments are sort of subordinated in the draft, but they're there and they're really there in the cases that Bertrall discusses, right? The idea that agencies can draw lines and courts can't, right? I read Washington v. Davis not just as being about legitimacy, but also as being about, my goodness, all kinds of things have a disparate impact. To figure out what kinds of disparate impacts are unconstitutional requires a lot of policy judgments that we don't feel like we're well positioned to make. You know, where do you set the tax? How many tax brackets do you have, right? This is something that it's just difficult to understand how to do, and so let's let agencies do that, Bertrall might argue, and you know, I can definitely see that argument. The argument from legitimacy is essentially that agencies are more democratic, they're mission-driven, they're supposed to carry out a congressionally adopted policy which is designed to protect protected classes. That makes them different from the neutral judges, you know, neutral in air quotes judges. Okay. That is a powerful argument in the abstract. But doesn't this depend on the politics? And so I want to take some of what Gillian said and just sharpen it a little bit. So would we feel, and Bertrall, would you feel the same way about this argument if the question about what agencies that protect suspect classes do in conservative administrations was not, are they going to stop protecting them so much, but are they going to adopt a right-wing view of what protection of suspect classes means? So that means elevating religious minorities and their practices and their desires over the rights of women, over the rights of racial minorities, over the rights of LGBT individuals. Do we say at that point, well, the agency has a special role in determining how to protect suspect classes, so let's defer to them? What about, just to take an issue that I dealt with in my time in enforcing the civil rights laws at the Civil Rights Division, what about a vision of what suspect classes are in voting that's a very localized vision that says what we really need to worry about is white people who live in majority black jurisdictions? Now, this is not fanciful. The George W. Bush administration went on a Moby Dick-style hunt for a majority black jurisdiction that was discriminating against white voters. They found one, Noxubee County, Mississippi, threw a bunch of resources into doing a case there. It became a cause célèbre. On the other hand, I can perfectly well say that's a vision of suspect classes. I think it's wrong. I want to disagree with it, but should we defer to it? And if not, why not? Now, Bertrall's argument seems to rely on the idea that mission-driven agencies will save us, that mission-driven bureaucrats will save us, and I think that history is not on our side on that. The history of the Civil Rights Division, not just in George W. Bush, but also under Brad Reynolds, when in the Reagan administration, when it started enforcing Title VII against affirmative action plans, and started allying itself with the anti-abortion movement. The Civil Rights Division under George H.W. Bush, which is one of the examples of mission-driven folks in Bertrall's piece, actually I think of as a very political story, right? So George H.W. Bush aggressively enforced the Voting Rights Act. Now, part of the story, as Bertrall says, is you had folks in the voting section of the Justice Department who cared about enforcing the Voting Rights Act. They were working with civil rights groups, and part of the story is the Republican National Committee decided that aggressive enforcement of the Voting Rights Act following the 1990 census would pack minority voters into districts that would ultimately reduce the number of Democratic districts and increase the number of Republican districts, which some people say was a big part of what led to the Gingrich takeover of Congress in 1994. It's not just mission-driven people, it's also politics. The Department of Education, which is a major agency discussed in Bertrall's piece as well, right, only comes to really enforce the rights of poor kids or enforce the interests of poor kids in the Obama administration because the Obama administration at the political level takes an interest in it. Okay, so I think the strong claim is difficult to justify once we think about politics, and in fact, it makes me really nervous once we think about politics. The weak claim, so I totally agree as a normative matter that agencies enforcing civil rights ought to get no less deference than anyone else. I think, though, that when we think about this in terms of politics, maybe the decisions of courts that give less deference to administrative agencies that enforce civil rights aren't doing it because, as Bertrall suggests, they think that agencies are getting into constitutional space, and constitutional space is judicial space. Maybe they're doing it because we have conservative courts, and conservative courts don't like the on balance, liberal actions taken by these civil rights enforcement agencies. And again, go back to my rule of thumb about EEOC deference, and I think that's true just in general. I think you really see this in the Supreme Court decisions involving the Voting Rights Act in the 1990s, actually, right? So you see in the Shaw v. Reno line of cases, Justice Kennedy in particular, you get this sense from him, right? He talks about how the Justice Department adopted the Max Black policy. He thought the Justice Department was captured by people who had the wrong substantive views, and he wanted to do something about that. Okay, so I think thinking about politics, undermines a lot of the argument of Bertrall's that's pitched at the level of abstraction and institutional competence. Mila's paper is really interesting, right? Because Mila's paper is, at some levels, an argument for rejecting even the weak claim in Bertrall's paper, at least in the important category of cases where agencies are interpreting statutes or agencies are carrying out programs that involve the spending of money. But again, it seems like an oddly abstract, apolitical kind of argument. Again, the politics are there, right? It's not that the paper is innocent of the politics. It's just it works really hard to try to be innocent of the politics, right? So I would argue the story, particularly of the Affordable Care Act, is not a story of institutional competence, which agency is better to decide this. It's a political struggle, right? You had a brief period of unified government in which a liberal, relatively liberal, somewhat liberal majority passed a law that passed a law, the Affordable Care Act, that did certain things. They appropriated certain funds for that. Then we got polarized, divided government very quickly thereafter. The new Congress couldn't repeal that law, but could fail to pass certain laws, so they didn't appropriate certain funds, but they did appropriate other funds, and you had an administration that that continued to be run by the political faction that supported the ACA, that had to make the best of the situation, that had to figure out how to deal with these conflicting instructions from different institutions over different periods of time controlled by different political entities. It was a zero-sum conflict. I don't think anyone in the Obama administration who was saying, let's find a way to finance the risk corridors, was saying the reason why we should do this is because HHS has greater expertise than Congress in determining where the money comes from, right? They were trying to save this statute. And so I think thinking about it in terms of institutional competence misses an important part of the point. And I think when you think about even breaking down the institutional competence issues, and I'm being very negative, I really love these papers. I mean, I just want to say, like, this is just how I am. I said to Nina Mendelsohn earlier today, I'm like the rudest person on the Michigan faculty, and Gillian said, no, you're like the rudest person in the legal academy. So here I am. But this is just, it's more fun to have an argument. So think about it in terms of expertise. Does Congress or OMB have greater expertise in determining how to allocate funds? Well, A, I don't know, right? And I think you could make arguments for both. B, is expertise even the way to think about that? It's an oddly technocratic way to think about something that's really a matter, as Matt Adler was talking about before, of distribution, right? These are distributional political questions. Accountability. So do voters have any idea about any of this? I totally agree with Gillian that we need a richer language, we need a richer analysis of accountability. I'm sorry that Neil Siegel left, because he's written probably the best article on accountability in the federalism doctrine, at least that I've seen. But, you know, so I think there's good arguments that voters actually do less of a good job following what happens when you go down the ballot. So what happens at the presidential level is something that's likely to lead to more accountability, one might hypothesize. If you read Akin and Bartels' book, Democracy for Realists, people don't seem to vote based on policy positions anyway. They vote based on their sense of individual and collective identity, which I think throws into, you know, all kinds of chaos, these views of accountability. If you talk about issues of, entrenchment, the standing issue is a really interesting one that I'd love to talk to you about offline. If you talk about issues of entrenchment, I don't know why funding decisions are more likely to lead to entrenchment than non-funding decisions, whether we're talking about the legal entrenchment, like you're creating a contract or takings claim, or we're talking about the political entrenchment. So certainly in many cases, I can see that funding decisions will do that, right? They'll create a contract claim. They will create a system that people rely on, like Social Security. On the other hand, one might argue that what's entrenching about the Affordable Care Act is not the money going to people, but the insurance market reforms. You can't be discriminated against because of a pre-existing condition. You're not going to pay more because of your medical condition. You don't have any lifetime caps. And the fact that money was necessary in this case to make those things work, it seems to me maybe idiosyncratic and not telling us anything about whether money is more likely to be politically entrenching. And of course, we all know administrative agencies can do things that take people's property all the time. I mean, so there's an argument in Mila's piece that's sort of reminiscent of Justice Douglas in the Youngstown case, where he says, he basically makes this argument that because only Congress can fund appropriations, only Congress can authorize the taking of property. But we know that rule isn't followed all the time. There are many circumstances where an agency actually does do things that lead to takings liability. But in general, I think these are the wrong way to think about it. I think the right way to think about these issues is to think about it in terms of there is a political struggle going on. And all of the questions, and I felt this way about the first panel too, all of the questions about, this is in part the response to the question that ended the first panel, questions about what are the best institutions. I just want to totally, associate myself with what Chris said. I don't know that there is any transcendently best institution, and I think we need to think about this in a much more granular political context and recognize the right answer may change in different contexts and different times. But with that, thank you very much. I know I won't be invited back.
So we have about 10 minutes for questions, but before we open it up, I want to just give Bertrall and Mila a chance to respond briefly if you want to.
Briefly. I might need another 20 minutes on the podium to respond, but I want to say thank you for the comments, for taking a close read of the paper, and for engaging me. I've seen you operate before, Sam, so I was anticipating the vigorous response. What I will say is that, yes, I think that a missing dimension in this paper is the political dimension. And I think that, yes, from what I've seen, at least, admin law scholars tend to abstract from the political dimension, in part because it's hard to know what to do with the political dimension. I think that, what I would say in response, and I'll just say in response to one question to not try to occupy too much time, is that, well, what would I say about an administrative agency that decides to read these civil rights statutes in a way to protect, a different set of minorities and subordinating the minorities that I think should be subordinated and protected? I am okay with that, and I'll tell you why I'm okay with that, because I think that what then emerges is what I hope would emerge, and this kind of is in tension with another point that you made, is that what becomes part of the calculus of democracy and what becomes part of the calculus of elections is what agencies are doing on these fronts, right? And so then you can have, in terms of people importing that as part of their decision making, insofar as they make decisions on policy, which I think you make a good point that most people do not, but insofar as they do, right, then we can have, it reinforces the legitimacy of what agencies do under a particular administration, as opposed to when their decisions are, muddled up and hidden. It becomes, in a sense, like parliamentary government in a way, in which the executive is a part of that parliamentary government, and they kind of go where the party goes within the constraints of the statute. I think the statute should provide some constraints in that way. The weak version, the strong version, the points that you raised, Gillian, and the three different ways of thinking about what I'm arguing, those are all entirely new to me, but I'm glad that you brought them here because they really changed my frame of thinking about this paper, and it shows how much more work I need to do in answering some of the questions of how I reconcile this with such issues as a City of Bernie question, which is something that I have to struggle with. So thank you both.
So thanks from me too to both of you. That was invigorating. So let me try to explain a little bit about what I was trying to do with the politics here. So the story you tell about the Obama administration being elected, the statute, Sam, talking to you, the Obama administration being elected, the statute getting enacted, and then a gridlocked Congress and an agency and an executive branch and a Congress engaged in this kind of hand-to-hand zero-sum combat with, that is a story you can tell not just about these particular case studies, but about lots of different regulatory areas, and you will each have your favorites. So when I was looking at this, at these spending decisions, what I was trying to understand was what I was trying to show in this paper is why should we feel so differently about this particular resolution of this, hand-to-hand combat political fight than we might say about the Clean Power Plan or some other regulatory decision like DACA or DAPA that has its, these decisions may have their own problems and issues. But it seemed to me that there are unique ones that arise in this context. So it's not enough to, at least to me, it seemed it wasn't enough to just say, this happened because of politics, because it happened because of politics, but do we feel good about the outcome or feel bad about the outcome? And in certain situations, like, the exercise of enforcement discretion or the regulation of arcane details of power plants, we might feel quite good about leaving that with the relevant agency, whereas with these two case studies, I argue we should think twice. So it's I feel like the politics is the beginning, is the backdrop, but you can't escape the institutional competence analysis. At some point you have to decide or order things by whether they're good or bad. I'm just very enlightened by your remarks, and I just wanted to say that I do think that that a lot of this case goes away. A lot of what I argue goes away if the agency is just implementing a clear statutory command in the sense, and mainly for the reason there that it's then it's Congress then that's creating the entrenchment, political or political or formal. It's Congress that is dealing with the fact that judicial review is going to be absent. It's Congress that is sort of accepting the risk of lack of transparency, and it's Congress that is it's the one that's reaching the deal for how much money should be spent on what and who should bear the burdens for making those choices. So it may be that Congress is really bad at that also, but I'll just cite to Churchill again. So I'll be quiet now so we can have questions.
Question. Stuart.
I actually have a non-broad administrative law question. I want to save something to say at the end. Most people already said what I was going to say at the end today at 3:15 anyway. But I have a very specific question for Mila. So as you know, we have lots of tax expenditures that that agencies do all the time. So IRS manages tax expenditures, and you know that every economist will tell you that there is no difference whatsoever between a tax expenditure and an expenditure. It's the exact same thing in every relevant respect, except that most people think that they're different. I want to know, are you drawing a distinction between those two when you're thinking about how agencies handle it? It is certainly true that the Anti-Deficiency Act and the Miscellaneous Receipts Act, when I was at OLC, those were a big deal. Don't apply to tax expenditure. So there is a legal answer there. But I'm just wondering if you, in terms of you're talking about this in terms of expertise, what agencies do, all of those arguments, it seems to me, are the exact same for tax expenditures and ordinary expenditures.
Yeah, so the short answer is I would not draw a line between tax expenditures and other kinds of expenditures. I do think it's interesting that my tax law colleagues tell me anyway that the IRS purports to be applying the statute, not construing it. So it doesn't say, we're doing this, you ought to defer to what we think is the right policy here. It purports to just be doing what Congress does. Now, I don't know how much traction you want to be able to gain from purporting that, but anyway, I just thought it was an interesting footnote. But I don't think of them as being distinguishable. And if tomorrow the administration ordered the IRS to create a new economic entitlement that operated through the tax code, then I think the same critique would apply.
Eloise.
I would make a comment that's halfway in between this sort of technocratic institutional competence question and sort of also gestures towards the political reality of the situation. And so this is to push you on the lack of expertise on the executive branch side and to suggest that the transparency problems are maybe even greater than you're thinking, in which case that limits the political abilities to intervene. So I don't buy really the way you've laid out the sort of the comparative lack of expertise. And I think I don't buy it for two reasons. One, because that's the way the president's budget is set up. That's the whole purpose of doing the president's budget, as opposed to the system we had 100 years ago, where the agencies would come in one by one and give their budget to Congress. You know, the whole point of doing a president's budget is that the president sees everything, and the entire job of doing the president's budget is to make those kinds of cross-government trade-offs, including even in independent agencies, which I think is another sort of important thing to note there. And so then the second part of that is that Congress seems to think this is important too, because it's continually increased by statute the role of the president's budget and the role of the executive branch in putting all of this stuff together. And then also, even if not by statute, implicitly seems to buy the importance of the role of the president in putting that together, because there's all these constraints that OMB and the president put on what agencies can say to Congress when they're sort of asking for their money. And one of the standard responses, if Congress tries to, if you know the committee hearing it tries to get more information about, yeah, but agency, what do you really want, right? The agency is supposed to say, what I really want is what's in the president's budget. The president has oversight over the entire government, and so you know, there's limits on the agency being able to tell Congress what they had originally asked OMB for. So I think the whole structure is set up to rely on. So I basically think both descriptively, the executive branch has massive amounts of expertise to do this cross-government wide thinking. And then I also think legally, Congress has given it / authorizes / likes it. So that's on the kind of expertise front. But the transparency side, I think, is really the problem in what you're talking about, not only because of these sort of like hidden stuff in the budget, but because the kinds of programs you're talking about, I think, don't appear on budget because they are future spending, and they're kind of in the hidden way, not in the what actually has to be appropriated way. And so that's the kind of thing that I think becomes less transparent in its details. And then when you couple that with and here's where I would like to suggest that you go further, all of the kind of secret stuff in the sort of process leading up to the president's budget, that to me is the place to expand upon, but also push Congress on, because Congress seems to have accepted this sort of secret part of the president's budget, in part because it likes and it values the expertise that Congress has. That the president's budget brings to Congress. So I guess my concern and therefore vision would be an argument for increasing the transparency requirements, which I think would end up being healthier to our ability to have the political debates about it. So if we were able to, as a polity, even government watchdog groups, right? So even if the average voter isn't, voting that way, to have government watchdog groups that have access to more of that information and can push Congress to hold the agencies accountable. That to me is where the transparency gaps are even broader. So just like there's, translated narrowly into your paper, there's sort of like 15 pages on the expertise side and a page and a half on the transparency side. And I would absolutely, if not flip, I would absolutely build out the transparency side for the sort of the political values that Sam was gesturing towards.
Thank you. That's really helpful. Can I just quickly say, so I guess one question that I had about the budget process was to me it seemed as if these kinds of decisions just evade that process entirely. So even if it was the most expert, panoptic, knowledgeable, omniscient process in the world, this kind of a guidance, like CMS issuing a guidance or this kind of a rule, because it's off budget or because it's informal or done through this oddball form of lawmaking, it just doesn't get channeled through that.
But it's inconceivable to me that the budget side of OMB, so sort of the power of, so that in the paper that I just wrote, right, the power of the RMOs,
Right.
who have this constant oversight and relationship with, even if it doesn't end up appearing in the formal budget document, that kind of oversight, which I argue is even more present than the OIRA side, which is sort of a receptive, when are you going to, you give us your regulation, we'll review it. But the RMO budget side is just a much more constant relationship.
Right, so from absence of evidence, I've been inferring absence. But then the other thing is, what about the expertise on the spending? And I struggle with terminology here in my paper. What do you call this? The executive spends, but Congress taxes, right? Congress borrows. And when the executive has the power to tax through ambiguous statutes, it often doesn't exert that power. Because why? It's obvious, because it's not popular to tax. So you can say, I don't know whether to call that an expertise problem or a democratic accountability problem or a transparency problem or what, but somehow I need somehow to make convincing this point that to tax and to spend must be, the expertise for both has to lie in the same place. So expertise it's not enough to say I'm an expert spender when you're not the expert funder.
I think we're out of time. Thank you to our wonderful panelists.